Hey, Aaron Wills again, starting another reaction video on Wednesday, the 11th day of September in 2024 at 6:18 p.m. Along with welcoming you to my channel, allow me to thank you for watching. Please comment, like, and subscribe before sharing this video and turning on the post notification bell. Take some time today to remember those 3,000 innocent lives that were lost 23 years ago today when those cowards crashed into the Twin Towers of the World Trade Center. As I said, 3,000 innocent lives were taken that day.
You like these Wranglers?
Oh.
Yeah, they're cool. These are cargos, man. I mean, you enjoy that $5, man. This pound.
You didn't know?
Yeah. A little airport today.
What happened here?
I'm happy I got paid, man. Money talks. Yeah, you can
Backspace. YouTube.com. Where's that at? There's YouTube.com. Enter. Alright. Please forgive the sniffling and the clearing of the throat that will be taking place during this entire video, I'm sure. Alright. We got Right With Me. From how long ago? There's still 59 watching. That's the current Right With Me video, the stream, I guess. I did Jim Maresky in my last video. Well, I did Jim Maresky in my last lifetime too. Not really. Defense arrested by default. I don't get that. Let's watch what happened there.
Ascension WoW is a standalone World of Warcraft private server that
This is the guy who ran his Ford Escape into the Washington, I don't know how to pronounce it, Washaqa County Christmas parade, killing 6 and injuring 12 more. His defense is that the car malfunctioned and that he couldn't stop. He was blowing his horn the whole time. The prosecution said he did it on purpose and that there was no malfunction to the car. He tried to maintain his innocence by saying there was a malfunction and that he didn't do it on purpose. And in his closing statements, he tried to tell the jury that there was a class action suit against Ford for this very problem. It accelerating and not stopping. And the prosecution had to say, objection, that's not true. And he just kept going saying it. And
Find him everything. What's one?
what's mine?
108.
Okay. My blood sugar, in case you were wondering, or in case you care, is 108. As I was saying, this is Darnell Brooks, who, Darrell Brooks, not Darnell, Darrell Brooks, who claims that his Ford Escape on November 21st and 21, his Ford Escape malfunctioned and he couldn't stop it as it crashed into a Christmas parade, killing 6 and injuring 12 more. Let's see what he has. It says that it says defense rested by default.
What's getting me?
I don't guess that means. I guess we'll find out in a minute.
Imagines WoW in a brand new way. Instead of choosing a classic character select, you'll instead take a
Yeah.
You got to be a party game too?
Yeah.
I don't know what's going on. Is there no volume or is no? Well, no one's talking, obviously. And he has no witnesses to call, and that's why he was forced to end by default. I don't know what's going on. There's some noises kick in, though.
Wisconsin versus Daryl Brooks, case number 21 CF 1848. May I have the appearances, please?
Morning, Judge Sue Upper, Leslie Basie, and Zach Woodshell appearing for the state of Wisconsin.
Here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all my rights here this morning.
Yeah.
All rights reserved.
All right, good morning as well. The records reflect the individual known to this court as Daryl Brooks is present in person in custody. However, he is wearing street clothes, a suit and tie, and a mask.
For the record, I don't consent to being called that name.
It is noted. All right, Mr. Brooks, just preliminarily, do you anticipate calling any additional witnesses today?
For the record, I don't consent to being called that name. And what was the question?
Do you anticipate calling any witnesses today?
Oh, yeah?
Shut up.
I don't believe today.
Well, we are here for the continuation of testimony. The only witness that I'm aware of that's on your list that you added is your mother, Dawn Woods. So I would expect that if she's going to testify, she would be here. Otherwise, I will be going through the colloquy with you as to whether you intend to testify today or not.
Did you receive my ICS that I addressed to you?
I haven't looked. Let me look.
That's nice, yeah.
Actually, I addressed one to you and then one to the prosecution. Is the audio?
It is. The audio's on. Do you know when you sent those?
Saturday. So that would have been the 20.
Maybe that's why the defense rests by default, because he has no one to call to the stand. And he decides not to take the stand. So it doesn't mean the defense rests by default. I'm sure that's what it means. He said that his mother's supposed to be there, and he called his mother, and she was not there, I guess. So if he has no more witnesses, then the defense rests.
22nd.
State receive anything through, like, the inter-office communication?
We have not. I just checked this morning to see if there's anything new. Nothing has been received at my office. And I should say the clerical that was assisting me went to the mailroom to double check. So not only has it not made its way to the DA's office, it hasn't even made its way over to the mailroom.
I can email the jail administrator to find out if there's anything in transit, if there's no objection from the parties, from the state.
No objection.
From you, sir?
No objection. I definitely want those documents received as they obtain important information.
You said you forwarded them to a staff member on Saturday?
Yes.
Do you know if that was morning, afternoon, or some other time?
Maybe in afternoon.
And those are 2 ICF forms?
Yep, one addressed to you directly and one addressed to the district attorney's office.
The same clown. Same clown fluffers.
When you're running a small business, every day presents different challenges and opportunities. There are countless tasks that need to be juggled daily. That's why finding tools that can streamline
I'm sending that. I will send it with high importance and we'll see what response I get. But I don't have anything. If you want to generally tell me the topic, we can cover it verbally.
The topic is pertaining to exculpatory evidence. Some things were learned, and once they came to my attention, I felt the need to immediately address the court about this information.
All right, what information make an offer of proof for me, sir?
The expert witness for the prosecution in regards to, I believe it was inspecting the vehicle, Officer Ryan Schultz. Question was asked of, did he know if there were any recalls on that vehicle? And I believe that a Brady claim should be visited because there were in fact recalls on that vehicle. In fact, there were recalls on the Ford Escape models from 2008 through 2010 in regards to the throttle body malfunctioning and causing the vehicles to accelerate and not being able to be stopped. There is a class action lawsuit where Ford company were sued because of this, and those vehicles models from the year 2008 through 2010 were recalled, and that is very important information in regards to the vehicle in question being a Ford Escape 2010. This information is very easily obtained just by pulling it up, and you will see a class action lawsuit. Obviously, if it's a class action lawsuit, then it's pretty easy to...
So what's your request, sir?
My request is to find out if Officer Schultz knew, to find out if the prosecution knew that there was a recall on those vehicles, and in light of the fact that these vehicles were recalled because of this malfunctioning throttle body for I believe it's counts 1 through 73 to be dismissed.
All right, what's the response from the state defendant?
Thank you, Your Honor. As Trooper Schultz testified during his examination, consistent with our research, there are no active recalls listed for the Ford Escape. as Trooper Inspector Schultz noted during his testimony, that Ford listed an extended warranty for the throttle body on the Escape. The warranty was extended to 10 years of age and 150,000 miles. The Escape is more than 10 years old and has more than 150,000 miles. Also, he noted specifically in his report that he did not note any defect in the throttle body as previously described in this report. There was no recall in the throttle body. NHTSA did do an investigation into allegedly defective Ford throttle bodies, which would have impacted this year. Basically, the electronic throttle body failures would have resulted in engine stall or surge while entering traffic from a stop position or while driving at highway speeds, neither of which I believe occurred here. Further, Inspector Schultz would testify that that does not prevent the brake from working. So if this had been activated on this car, which it was not, but if it had been, and this defendant would have pushed down on the brake, it would have stopped the car. Further, if this was a problem, there would have been the malfunction indicator lamp or the wrench light would have been illuminated, as Trooper Schultz or Inspector Schultz testified when he started the vehicle and checked the indicator lights. None of them were lit. Further, if there was this, he would have observed material buildup on the commutator. There was no such buildup observed. There were no problems with the throttle, electronic throttle body. That was part of his report. Therefore, this is, although there may have been some cars who had this problem, the car that the defendant was driving on this day did not have that problem. That was testified during the vehicle inspection. The defendant had the opportunity to cross-examine Inspector Schultz with regard to that. And again, in running the defendant's mom's VIN number through NHTSA, National Highway Traffic and Safety Administration, there are, for this particular VIN number, for this car that the defendant was driving, 0 unrepaired recalls. So it's a moot issue.
I don't believe it's a moot issue, and I actually have, the report should be in the mailroom as we speak. I had everything sent over priority mail, the actual information about the class action lawsuit, the actual information about the recalls for those models, like I said, 2008 through 2010. Now, in all fairness, Your Honor, that's why I was asking for a Brady claim on this. Seeing as how when vehicles are purchased from the manufacturer, they're still sold as is. There would be no way to know that there's anything malfunctioning with the vehicle until it actually happens. And seeing as a class action lawsuit, no one would sue the Ford company if there weren't malfunctioning vehicles. There would be no class action lawsuit if...
She just said there was no class action lawsuit. He's making that up in a last-ditch effort to explain why he killed all those people.
These vehicles were not malfunctioning. And I believe with that, like I said, the information is easily obtainable. I should have the information in the mailroom right now that you can readily view this information about the class action lawsuit, about the recall. It wasn't just the 2010 model in question, it was 2008 through 2010. the information about the malfunctioning pertains strictly to the throttle body.
Let me address your claim, sir. So, not trying to cut you off, I don't need the specifics about a class action because as it relates to this case, the fact that there's a class action would not mean there's a Brady violation by the state. In fact, you even indicate it was readily known and something you were able to find out. I'd further note that you had a full and fair opportunity to cross-examine the inspector regarding his mechanical inspection. It's not new information. And more importantly, as it relates to this particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems. Because, again, there was a full inspection. That report was provided to you. He testified on direct examination about there being no active recalls, and more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it. I am aware that the ICF, I did receive an email, it's one page with what you said. I have to turn my head, I gotta figure out how to flip it. So give me a second.
Okay. And just for the record, Your Honor.
Hold on, let me finish my record, okay? So I'm going to turn, because it's the only way I can read it. It says, your ICF says the state's expert witness who did the inspection on the vehicle in this incident needs to be recalled no later than Wednesday. I just learned of some information that is extremely vital. I understand the information that you're providing me, but again, you had a full and fair opportunity to cross-examine this witness. This information was apparently well known. I'd also note the vehicle's registered to your mother, and from my understanding of recalls, I think what is common knowledge is that a registered owner would receive information regarding the recalls and what to do, and presumably she would have provided that information to anyone operating that vehicle or taking care of it. We have none of that information before us by way of fact or even an offer of proof that even she received that information and did nothing with it, or whether anyone else who operated that did anything with it or not. The bottom line is there is absolutely no Brady violation by the state. This is not the type of information they would have been required to turn over. And from my understanding and review of Exhibit 83, what's important to this case is that the mechanical inspection specifically looked at that issue nonetheless and found that as to this particular vehicle, there were no issues with that would have impacted the mechanical function during the incident in question. I'll accept the state's offer of proof as to what would have been the issues based upon the information provided. And again, without anything further from you by way of your offer of proof, I can't make a finding, number one, that there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact whatsoever. So I'll deny the request to dismiss the case, and I'll deny the request to recall this witness. Hold on. Let me have the state just make their statement. I'll give you the last word on it. Go ahead.
Thank you. The Inspector Schultz's mechanical inspection report was provided to the defense on April 29, 2022. I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in front of him, and it was asking questions directly related to information contained in that report.
All right, go ahead, Mr. Brooks.
When you spoke to the owner of the vehicle, that's who gave me the information. My mother gave me the information of this. I had no knowledge until she told me. And that's how I came into the information. And she was the one that said, I'm going to send you all the information that you need so you can present it to the court. So I
understand that, sir, but your request is not timely. So you have had this information for quite some time, either through counsel.
I did not have it for quite some time.
Let me make my record. Either through counsel.
It was just told to me.
That's not what I'm saying. You've had the information about this report for quite some time, either through prior counsel or through all of the discovery that was turned over to you when you took over your representation of your own case. The fact that you have now learned this, it's a little bit too late. And I understand that may seem fair to you, but even when I consider the information that you're providing to me, it's speculative on your part as to whether there's any impact on this particular vehicle because of the inspection that was done. And you had a full and fair opportunity to cross-examine the inspector about information that was readily obtainable and researchable by you prior to the time that you cross-examined this witness.
It was not readily available for me to expect at the time. I don't have access to the internet. So how would I be able to...
Mr. Brooks, you're telling me your mother had that information.
No,
so,
I'm
and
telling
I'm
you,
trust...
she just told me this information. I have the phone calls to prove it.
I understand that. I'm denying the request, sir.
And I would like a...
So that's my decision.
I object to that, Your Honor.
I understand.
I
I've made my
object to that.
decision. I expect that you respect the decision, at least
No.
as we're not going to debate it further.
Yes.
I now have the
It needs to be-
ICF,
it
the
needs to
one
be
from the state
addressed,
that
Your
provided
Honor.
to the state.
It
Madam
needs to
Clerk,
be
I just gave
addressed.
that to you. All right, so
I
Mr. Brooks, in
respectfully
light of
object.
that,
I respectfully object, Your Honor, and request the legal reconsideration of your ruling, Your Honor.
it's denied. The request for reconsideration is denied. There's no legal basis for me to do
I
that at this
respectfully
point.
reject that ruling and take exception to that ruling, Your Honor.
All right, Mr. Brooks, we need to keep going.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
Did you know that there are over 500 strains of probiotic bacteria? Each strain has their own benefits, but there's one particular strain that stands above the rest. So the name Lactobacillus reuteri is quite the long tongue twister, so we'll call it L. reuteri for short. L. reuteri is one of the more extensively...
I provided an oral ruling today. The record stands, sir.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue?
Your request is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal of this matter?
What?
I wouldn't be the one you would make that request to, sir. So I can't
For the record, may I
answer that
move
yes
to
or
stay
no.
these proceedings until the instant matter is adjudicated by a court of competent jurisdiction?
That request is denied.
Based on what law or fact, Your Honor?
The request is denied.
Based on what law or fact,
What,
Your Honor?
any other requests, sir? I'd like to move on.
Based on what law?
There's no
Or
legal
fact.
basis that you've stated for me to do that, sir.
It has been, Your Honor.
The request is denied. The request is not a proper motion. There's no legal support for the motion. There's no factual support for the motion. So it's denied.
For the
And that, ladies and gentlemen, is why you don't defend yourself.
record, it appears that this court is acting in contempt of the law, Your Honor. Can you show me how, where this court is following the law of respecting this matter?
That's a very vague statement, sir. There's no legal relief that you're claiming. There's no motion before the court based in law or fact. So this court cannot address that last statement of yours.
Your Honor, with all due respect,
I think if you keep saying it, it'll change something. What do you think? Those of you watching at home. Think that you just keep saying the same shit? All of a sudden she's gonna change her mind? With all due respect, Your Honor, I object to your decision in wanting a lawful explanation of, denied. Your request is denied. In all due respect, Your Honor.
I would like a motion for finding a fact.
Denied.
Under what law and fact?
I made an oral ruling, sir. There's no requirement I do so in writing.
So you're denying a legal, you're denying a motion
Yes.
for finding a fact.
I am.
So how do I know what you're doing is legal, Your Honor?
All right, Mr. Brooks, we're going to move forward. At this time, I want to
How do I know that this is legal, Your Honor? Can you show me that it's legal?
Mr. Brooks, we're moving forward. So your
Doesn't
request
seem
is
like
denied.
it doesn't seem
Mr.
like
Brooks,
you're-
I need to give you some
It
advisements,
doesn't
and I'd
seem
ask
like
that
you're.
you
I
stop
don't need
interrupting
your
me.
advice.
No, I have to give you
you.
advisements, sir, regarding your right to
I
testify.
need to do your job without prejudice and without
Mr.
bias.
Brooks has
Your
now
Honor.
interrupted me multiple times. He's failing to respect the court's oral rulings here today. It's something that he's done repeatedly throughout this trial. Mr. Brooks, I need to go through some advisements. Unless you have a witness to immediately call, I need to go through
He
this
doesn't.
particular discussion on the record with you regarding your right
don't-
to testify.
You don't
Do
need
you
to
have
go
a witness
through,
to
You
call,
don't need to go
sir?
through anything with me on record. You
Actually,
need
I
to,
do so,
Actually,
sir.
you
That is
don't.
required by law.
Actually, you don't. You need to do your job as a public servant.
Mr. Brooks,
and honor the oath that you
I
took,
need to
Your
go
Honor.
through these advisements, and if you're going
Honor
to keep
the oath.
interrupting me, you will forfeit your right to be present, and you
So
will
you're
be
holding me in
removed to
contempt
the next courtroom so that I can properly go through these advisements
And I
without being
still-
interrupted.
And I still don't have to answer. I still don't have to answer whether I'm in this court or not. So you're holding me in contempt yet again.
Mr. Brooks, I've not held you in contempt. I've found that you have forfeited your right to be present by your conduct, which is one of the options available to this court under Illinois versus Allen, under State versus Vaughn. It's also referenced in State versus Anthony. So I am going to keep going, sir, despite your protestations.
Your Honor, with all
I need
due
you
respect, in
to
Illinois
not
versus
interrupt
Allen,
me.
in
This is
Illinois
another
versus-
interruption.
In Illinois versus Allen.
Mr. Brooks,
do
I'm
they
not
say-
going to have a debate with you on
I'm
the
not
meeting
trying to
of
have a
Illinois
debate.
versus
I'm not
Allen.
trying to have a debate.
You are
I'm really
advised
trying
that
to
it
understand
continued.
Illinois versus Allen.
Mr. Brooks, you are advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but you saying that
I've said
forfeiting
that
my
multiple
right.
times.
You
I've
saying-
given you multiple
You're
opportunities to
holding
stop
me in
interrupting
contempt.
me.
You're holding me in contempt.
Mr. Brooks,
By
I'm not holding
removing
you
me
in
from the
contempt for
courtroom.
the second time here, and I've
Your
also
Honor.
repeated that.
Your Honor,
He's
with all-
interrupting me yet again.
with all
Mr. Brooks,
respect-
I need you to stop talking.
But
You shut your fucking mouth, idiot. What a fucking moron. First of all, he chooses to defend himself when he has no leg to stand on. And he wants to argue with the judge after she told him to shut the fuck up. What an idiot. No wonder he got like 10 lives and plus 700 years or whatever it was. Like 3 life sentences in consecutive order, in consecutive whatever. And then like 700 years on top of that. We'll play that right after this. I saw it earlier. But he got sentenced to forever. And luckily he didn't get the death penalty. I guess it wasn't available in Wisconsin.
with all respect,
That's just bald ballerina. That's creepy. That's a bald ballerina. That's really creepy.
in Illinois versus Allen.
All right, Mr. Brooks continues to want to debate with me the meaning of Illinois versus Allen. It is a clear indication to this court
trying to
that
understand,
he
Your Honor.
wants to disrupt these proceedings, even
That's
in
not
a
true.
mild manner tone
That's
of
not
voice.
true.
I've
I'm
reminded
seeking
him
to
repeatedly
understand, Your
regarding
Honor,
the standards
because
of
it doesn't.
civility, and one of the
Illinois doesn't.
bedrocks is that he
Illinois
not
versus
interrupt.
Allen does not state.
All right, I'm going to
that-
remove him to the next courtroom so that I can go through
It does
proper
not state-
advisements with him without being
It
interrupted.
does not
We'll clear the
state
courtroom
that
and
you
we'll
can be
resume
present from
once he
cameras.
is over there. Again,
It
I'll make
doesn't
the
state that
appropriate
you can be
findings when
present
he is
from
there.
cameras, or that you could be,
Yes, we're off the record.
or that you
until,
could be.
he's in the
Okay,
other
so
courtroom. I'll
you're
be
making a
stepping off.
tacit agreement.
That's early. 5 till 9. He's already running his fucking mouth. I'm glad they kicked him out of there. Now he says one more witness to call. He has to examine her, or he has to examine her from another room. That's what he gets. What is it? It's not on pause for that. Oh. The court's adjourned. Let's wait how long? Until 9 o'clock? Maybe here we go. Then again, maybe not.
Yeah, your toilet jeans can muddy and not.
We're just gonna sit here and wait, I guess. Not a very exciting video, is it? Alright. What got going on here? Fox 6. But it's not putting anything. This is from like 3 years ago. So, I don't know. I wish they would have learned how to speed it up. Right, oh, here we go. Oh no. It's just telling us it's in recess. Waukesha, Wisconsin. Wisconsin, whereas Brooks Court is in recess, alright? Dre was excused for the day. Is this the same for the Mashaka? No. Who was the kid in Kyle Rittenhouse? Was he the Mashaka? The Mashaka kid, or whatever they call him? Mashaka kid. Hey Google. Hey Google. What was Kyle Rittenhouse's nickname?
According to Lab Bible, the DJ was actually born as Adam Wiles, something his friends and family continue to call him while his fans probably only really recognize Calvin Harris. The star added, "No one calls me Calvin. It's horrible and it's not my name. You might as well be calling me Mr. Lobby."
Hey Google. What was Kyle Rittenhouse's real nickname? Fuck. I do that again.
According to the Mirror, no one calls me Calvin. It's horrible and it's not my name.
Calvin? Who's
You might
Calvin?
as well be calling me Mr. Lobby, he explained. At the start of my career, people were meeting me for the first time and I let it slide.
Hey Google. What was Kyle Rittenhouse's nickname?
These came back from a search.
Just tell me, don't anyone came back from a search. Alright. Now what we got going? What's the deal on this? It's pretty much all of it anyway. Alright, let's see. What we got? Let's search for some writing advice. From who? Let me shout writes. Shaylin writes has posted anything recently. See Abby Evans' advice on dialogue. Evans. Abby Evans. I-L-O-G-E. Who's that shit? That's not Abby Evans. She might be better looking than Abby. Believe it or not. This is Abby Evans. I don't know who that is. Which one looks better? Leave a comment down below. Okay, let's see. Playlist for Abby Evans. Let's see if she has a list about dialogue. Nurse of writing. Let's see how much I do. Nurse of writing. I'm gonna be honest with you about what I do right and what I don't do. We'll see what I'm supposed to be doing, and I'll tell you what I do and don't do. Here we go. So buffering. Great.
Getting my first client made me feel like I actually knew what I was doing. When I was figuring out my LLC, I didn't have to know how to do any of that because Zen Business gave me options. I also didn't have to know what documentation I would need to run my business.
Welcome, writers. I passed gas. What is that? Spearmint? I don't know what it is. What? WIP, what is that? What is WIP? Sprint 14, 4 minutes and 49 seconds remain. I could be writing instead of making the video. Supposed to be a writing sprint, but I don't know how I can keep this up and pull up my story at the same time, or I might do one of these things one time. It's very nice writing music to listen to. As a matter of fact, I hate when I do these writing videos because it makes me want to hang it up and work on my story, which I think I'm going to do that now. I'm going to tell you, peace!